I now call the fourth case on this morning's docket, case number 119198, in the matter of Linda S. Dickens.
May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. Mr. Chief Justice, may I reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you, Your Honor. As this court is aware, this is an original proceeding in attorney discipline. There were 3 different cases that were consolidated for the hearing. Prior to the hearing, the respondent stipulated to violations of KRPC 1.3, 1.4, 1.5, 1.8E, 1.16, 5.1, 8.3, and 8.4G. After the hearing, the panel found additional violations of KRPC 1.1, 3.2, 8.4C, and 8.4D. In the first
3 cases, you had the employment case and you had the couple, and is this, the other one is the diversion case? The loan?
Yes, Justice Johnson. The first case that came to us was a loan to a client who is actually the client that is in the third case. And we learned that there had been a loan. She stipulated in that as part of participation in the attorney diversion program that conduct violated 1.8E. And then she failed to complete the terms of her diversion. And she was afforded an opportunity to respond as to why the diversion should not be revoked, and she did not provide any information. And then, as Justice Johnson said, the second case involves an elderly couple who were victimized by some unscrupulous investment folks. They lost a significant sum of money, as well as they were looking at significant tax liability. She agreed to represent them against these 2 actors on a contingency fee basis. No fee agreement was ever produced, thus the finding of the violation and the stipulation of the 1.5. Then the relationship deteriorated to the point that she threatened to sue them. She threatened to turn them over to the IRS. She threatened to tell their tax preparer to withdraw some favorable arguments that had gotten them absolved of any kind of tax liability. The clients actually ended up appearing in front of district court judge and asked that their case be dismissed because of how they perceived her conduct was against them. And during the hearings, respondent acted or explained that she was surprised that they were so dissatisfied. The panel made a finding that the relationship had been contentious for at least a year prior to the hearings. And then the third case involved a discrimination case for an individual that worked at the Power and Light District in Kansas City, Missouri. He alleged discrimination and that he had been assaulted and battered. And again, this is the same client that she loaned money to. And at the time, the respondent was a solo practitioner. She sued these pretty gigantic entities and just didn't have the resources to keep up with all of the different defendants that were coming after her. Eventually, that case got dismissed on summary judgment, and that decision was not appealed. She was disciplined by the state of Missouri from that case, and that was an admonition that she agreed to accept for violation of Missouri Rule of Professional Conduct 1.1, which is competence, and 1.3, which is diligence. In this case, she...
And that was just, in Missouri, it was just the one employment case.
Yes.
No.
She filed exceptions and briefed 5 issues, and I believe that they all relate to whether or not the record supports the panel's findings. The first issue was the ages of the elderly couple. I don't believe that it's necessarily material as to disposition or whether or not there's a rule violation, and the final hearing report doesn't make an exact finding of age, it approximates. The second issue involves when the respondent knew one of the parties that she sued on behalf of the elderly clients was judgment proof. And in her brief, she attributes testimony to the male client and suggesting that during their initial meeting, She told him that this individual was judgment proof and kind of infers that they were going to continue them with the litigation. And that's not what his testimony is. And I would direct the court to volume 2, pages 271, lines 12 through 25, and page 272, lines 1 through 12, as also is cited in my brief. And in her own answer, which is found at volume 1, page 104, paragraph 12, she writes that he was judgment proof according to court records. And the only court record that relates to that is the motion for summary judgment that was filed after she filed her lawsuit. So I believe that the panel's I believe that the record supports the panel's findings. And then the last issues, 3 through 5, all relate to the third case in which the suit was dismissed on summary judgment. And it's my position that she failed to designate a sufficient record for both the panel and this court to make a meaningful review. She refers to documents that were filed in support of her argument that she filed proper contradictory evidence. The Missouri court rejected it because it was out of time. Additionally, in the grant of summary judgment, the court did go through the analysis and there were facts that could not be controverted. For example, the client had a work comp settlement that related to the battery allegations in the employment case. And in that work comp settlement, he had agreed to accept the compensation, to release the person that she sued from liability, and to not attempt to recover any kind of more settlement money in the future. We're sort of far apart on disposition. The panel recommended that she be suspended for 2 years and imposition of the suspension be suspended and she be placed on probation for 2 years. She did file an affidavit and her probation supervisor also has filed an affidavit. She does appear to be in compliance with the terms as they were set forth both by her and the hearing panel. At the panel, I recommended a disbarment or at least a suspension. I still believe that the minimum recommendation should be an indefinite suspension. I believe that this conduct was egregious, especially the events relating to the elderly clients. It wasn't just a one-time heated exchange. It spanned a period of time. It was repeated. It caused them great stress and duress. So if the court determines that a lesser term of suspension is appropriate, I do think that there needs to be a 219 hearing because of the issues with her health and anxiety, just to make sure that at the time she is capable to return to the practice. I do not believe that this is a probation case.
And she represented to the district court that the husband was abusing the wife and that the wife was suffering from senility?
No. She
Okay.
represented that the wife was a victim of battered woman syndrome and therefore had been caused not to speak by the husband, and that the husband, because he was asking for the case to be dismissed, was acting against his own best interest, which in her mind triggered potentially the need for a GAL. And she never took any steps to find a GAL, to do anything further to that.
Does that conclude your presentation?
It does.
Any more questions? Thank you, counsel.
May it please the court. I'm Tom Hamill, and I represented Linda Dickens, the respondent, throughout this case. I intend to make a few remarks initially, perhaps 5 minutes, I hope no longer than that, to maybe give the court a little overview of what I've observed and some comments on some of the facts in the case briefly. But after that, my client, Linda Dickens, wants to address the court in explaining her conduct in this case. So, with that, what the counsel for the disciplinary office has said is essentially true. I first met Linda about 2 years ago, in September of 2016. She came to me. She had a letter from the disciplinary administrator's office saying that a charge had been filed against her by a couple in Johnson County over a lawsuit that had occurred there. Not too long after that, she came in again with another letter from the disciplinary administrator's office saying that the in-house counsel for the Cordish companies had filed a complaint against her, and that was going to be opened and investigated. When she came to me the first time, she was confused. She was frightened, and she was in a state of extreme anxiety. And I was frankly quite concerned about her health. We investigated these cases, and as we did so, as counsel has indicated, they filed a complaint charging, essentially there are two main cases. There's a case in Kansas City, Missouri, where she sued 2 or 3 companies owned by Cordish on behalf of a client of hers, alleging some employment discrimination. The other lawsuit was in Johnson County. What we found was that the disciplinary administrator's office filed a complaint, a 76-page complaint consisting of 213 paragraphs alleging basically 13 violations of 13 ethical rules. I have before me a woman who has practiced law for 30 years without an ethics violation until this time. She was an extremely good student, graduated with honors, was a law clerk for a federal judge in Kansas City, worked for a prominent law firm in Kansas City, was a successful practitioner, highly regarded and highly respected. I found that quite interesting, particularly when we looked at the complaint that was filed. And it occurred to me that all of these violations that are before the court happened in these 2 cases in a simultaneous time frame. They occurred between January 2014 and April 2016. We even prepared an exhibit, a trial exhibit at the hearing. It's a respondent's exhibit number 58. And through the use of color coding, we interposed the allegations in the complaint in Kansas City, the Cordish complaint with the complaint in Johnson County, and they occurred essentially the same time.
When did the loan to GC occur?
That occurred during the representation, during that same time frame. I don't have the exact date on that, but she was, because of her representation of this defendant in the Cordish case, her case was dismissed.
And so you started to represent her before or after
After all of this happened.
Before or after she was put on diversion by the disciplinary?
Afterwards.
Okay, so she was already on diversion when you started representing her.
She was.
And she did not complete that diversion, did she?
She did not.
And it was revoked in January of 2017.
That's correct.
And diversion is akin to probation. You have to comply with certain terms before you successfully complete it. She was unable to do that. So why should we have confidence that she will complete the probation given that track record?
Well, I think the court has to look at her conduct since these charges were filed. And as I was saying, it occurred to me that her conduct, frankly, was an aberration. It was not consistent with the pattern of her practice. And we began to wonder, why was this occurring? Well, we started looking at some of the detailed facts in the Cordish complaint. And she's going to address you and explain to you what she went through in that case. But basically, this was a very high-profile case in Kansas City. It was getting a lot of publicity on the front page of the Kansas City Star. All the news, the evening news, the local channels were carrying it because her client sued these Cordish companies and was alleging that there was prejudice against black people, and she was representing a black defendant who had brought a lawsuit alleging that he was unlawfully discharged. So during that litigation, which was going on at the same time as the Johnson County litigation, the Cordish company first, after she filed suit, they removed that to federal court. They had, 7 lawyers working on the case. She was successful in having it returned back to the circuit court in Jackson County. Then they filed a RICO action. The Cordish company filed a RICO action suing her and her associate working on that case personally. Filed it in district court before Judge Lungstrom. And a lawyer in my office represented her and was able to get that lawsuit dismissed. It was clearly a baseless lawsuit. But she was being come after, if you will, by the Cordish company. This caused great anxiety. She was having panic attacks. She her physical health failed. She began to have sciatica in her back. She got so worn out that her doctor at one point prescribed that she go home and have bed rest. Now this is all happening during these 2 cases. It's my feeling that the stress and anxiety that was imposed upon her in this Cordish case, which was taking place at the exact same time as the Kansas case, was causing her just to collapse. And her judgment was gone. And when she came to me, she was anxious, upset, combative, and we couldn't figure out what to do. We came up with a plan, and this is the answer to your question, Judge. Why should you trust her now? Rule 211 of our Supreme Court rules allows for a supervised probation plan. And we talked to her about that. We talked with KLAP about that. We talked with an attorney to see if he would agree to supervise her. And we gradually put together a proposed supervised probation plan. That plan went into effect on June 1 of 2017. And she has been on that plan today. Every day, she's currently on the plan, and she, Michael S. Martin, Mike Martin is her supervisor. He's filed an affidavit, submitted an affidavit, which I filed earlier this week, which states that she has been on the plan, she's in full compliance with the plan, and that he would be willing to continue as her supervisor if the court would so recommend. The plan requires him to visit with her every month, and in the plan she agreed to limit her practice. She didn't have the support and probably the experience to get into the Cordish case, and when she was trying to handle that case together with this other case, her judgment was gone. She was not using good judgment. She's admitted at the hearing, if you look at the panel's analysis of the hearing, she essentially stipulated to almost all of the alleged rule violations. The only violation she did not stipulate to was 8.4C, which says that her acts were dishonest.
Counsel, were you still wanting to reserve some
I
time
am.
for your
I'm
client
sorry.
to...
I want to conclude by saying
Counsel,
that-
I want to interrupt for a second because it seems like the threats to the clients, is a big elephant in the room here.
Okay.
And
Agreed.
it seems like you're trying to run the clock out. I know, I mean, and I want to talk about that. Is it your defense to that it happened, but it was just, as you say, an aberration, and that we shouldn't take anything from it because she has this long history of I mean, how do we, you know, it's sometimes really, really good lawyers do one really stupid thing.
Well, there's a couple of points.
And they get in trouble for it, and they're disciplined for it. And so why are we not supposed to discipline her for that?
Okay, well, good point. Damage to the client in the Cordish case. She made full restitution on her own. I had nothing to do with it.
No, I think we're talking about trying to extort $100,000 out of the elderly couple because the wife didn't tell her when she knew about that they'd lost their money, and it was on a contingent fee, and she demanded $100,000 and threatened to queer their deal with the IRS, threatened to tell their accountants to damage her, all for money, and so that doesn't seem to fit into an anxiety scenario.
Well, I've never had the kind of anxiety that I think she had. I don't know whether the court has or not, but I do know it interferes with your logical reasoning. I don't argue that she didn't do those things, but in that same case, before all that happened, she did save them a tax liability of about $200,000. So they were damaged by what she did after that, but they did get some benefit from that. I just asked the court to look very closely at the recommendations of the panel. They begin on page 141 of the hearing report. The panel found that she had developed this plan, a workable, substantial, detailed proposed plan. They found that the plan was presented to the district or to the disciplinary administrator and to members of the panel before the hearing, well before the hearing. It was clear to the panel that she had been participating in this supervised probation plan.
And how does that plan assure that we won't have a repeat of trying to get money from clients that's not due according to the employment contract through threats to get them into trouble? I mean, what in the plan addresses that? I've read Mr. Martin's affidavit and what all he's doing with regard to her cases and that sort of thing, but I don't see how that protects the public from that kind of conduct.
There's no absolute protection of anything. I mean, I can go berserk tomorrow and the public wouldn't be protected. She's had a history, a 2-year history of violating these rules. She's had a 28-year clean record. The purpose for these plans are to try to rehabilitate people. KLAP is involved in our plan. We have KLAP that works with lawyers who, abuse drugs and have all kinds of problems, and they work to rehabilitate them. And we're fortunate to have people like that. We're also fortunate to have Rule 211, which allows people like Linda to apply for these plans. And the last finding of the panel is that they recommend placing her on probation. She recommends it is in the best interest of the legal profession and of the citizens of Kansas. These are people who heard Linda during a 2-day hearing and were able to judge her person. And they saw what she had done. At the time of the hearing, she had been on the plan for several months. She's on the plan today. Michael Moore's affidavit came recently. He met with her on November 16th. She's in full compliance with the plan. She has voluntarily decided to limit her practice to those things that are in the plan: probate, transactional work, non-contested litigation, the things that got her into trouble. She's agreed to
me.
stay away from that.
Counsel, you're out of your 15 minutes and you still wanted your client to address us.
I'm ready to wrap up.
All right.
I just asked you to consider allowing her to continue on that plan, enter a order of suspension. Please stay the suspension to allow her to continue on the plan. She's done no harm since June 1 of 2017. She did no harm the first 28 years of her practice. I think she's a reasonable risk.
Thank you.
Thank you.
May it please the court. I am Linda Dickens. I've had my license in Missouri since 1983 and my Kansas license since 2011. So today I am a lawyer who's been practicing for 35 years. Just as my attorney stated, I had a 2-year really bad period, the most painful period of my life. A time period when other people trusted me to be in charge of important affairs on their behalf. In a time period during which I also was an officer of this court, pledged to uphold the honor and the integrity of our profession, not the least of which is to be honest and forthright and put my clients before myself. I failed that. I failed it in every way that has been stated to this court, and I take full responsibility for it. If you choose to suspend my license for a short period or indefinitely, I have no one to blame but myself. I was in a condition that I don't believe I will ever return to. I was nothing like that before the 2 years began, and I've been on a long but very fruitful journey back to full health, and I'm thrilled to stand before you today, and my goal is to demonstrate that. I want to jump straight to what I think is the most important issue as raised by Justice Johnson. How could I threaten clients? By saying that I might have to withdraw factual statements I made to the IRS, and I might have to withdraw factual statements that I made to their tax preparer, and that I was going to sue them to recover in quantum meruit the damages I felt I had suffered because the wife in this couple had misrepresented to me an essential fact, a representation she later admitted, but which caused us to lose on summary judgment. The answer is essentially this. The husband in that couple was an attorney himself, who I believe had had his law license for 62 years. Throughout the case, he legally debated the merits of it with me, and I think he enjoyed that back and forth. And when we reached this point of my calling them in to politely discuss what I believed was a deficiency by his wife that had unjustly affected me, a very polite meeting and discussion began, and I showed evidence of her earlier written statements and then what she had later changed them to. And he immediately said, "You may not talk further to my wife. I am our counsel." And from that point forward, it became a lawyer to lawyer debate and discussion. In my compromised, anxious state, I believed I was in negotiations with a lawyer, and he conducted himself as a lawyer does. He debated the legal merits, and then we negotiated back and forth. It was wrong of me to not stand back and look at the bigger picture and see that this was my client, lawyer or not. I could not negotiate with him, but I did. I conducted negotiations exactly as if he was opposing counsel. And I made a demand, and I made a threat. I will sue you. And I furnished him a copy of the petition so that he could look at the legal merits under Kansas law, and I furnished the cases to him so that he could see what the cases and what the law provided. And I did that because he kept saying a lawyer can never recover from their own client, and I, again, mistakenly reacted as if we were in a lawyer-to-lawyer adversarial relationship. That was wrong. I have never, on any other occasion, had a disharmonious relationship with a client, not any client, in 35 years. And I am deeply shamed by losing my objectivity and engaging back and forth with my client in that manner because it was wrong. I do want to describe to you the condition I was in at that time. His case, their case had already been filed, and we had lost on summary judgment 2 months earlier due to a statement his wife made that controverted what she had put in writing to me 2 times when I began my representation of them. But more importantly at that time, a year earlier, I had filed the employment discrimination case. 3 months after I filed it in May 2014, a very powerful multi-billionaire company sued me for RICO racketeering, and it was front page news, literally the lead story, and it was also the lead story on all of the TV news channels. My 1-year associate was aghast and in complete terror. And while I was not in terror, I was somewhat shocked. And anxiety and sleeplessness for me began immediately. 2 weeks later, I went to my personal physician and I described to her the difficulties I was having, and she prescribed antidepressants and another medication to help me sleep. I did well that summer, but as was described by Mr. Hamill, the extremely skilled party on the other side knew how to throw every stone in our path they could. We had a successful summer. We won every motion in that civil case transpiring in Missouri. And at the end of the summer, another attorney in Mr. Hamill's firm was able to successfully convince Judge Lundstrom to dismiss that case as without merit. Meanwhile, though, I had the additional stress of working with our defense counsel, trying to reassure my associate that this wouldn't be the end of his career, trying to assure myself it wouldn't be the end of my career, paying defense counsel, and notifying my malpractice carrier of what was going on, and that elevated my anxiety. And in mid-August, just before that case was thrown out, A death threat was texted to my cell phone in the middle of the night for the chief witness in this discrimination case that was pending. It sadly, it sent me over a brink with anxiety. I still remember that emotional fall. I went to my physician. We increased my medication. But at that point, it was my young associate and I. The only active case we were handling was the discrimination case, and discovery was only for a 6-month window, so we just moved as fast as we could and tried to keep up with everything possible. I recruited a 10-year experienced associate who was to begin working on this case on January 1st of that year. So now we have this cusp of the events occurring with the couple, and also kind of a pinnacle in my anxiety in the Missouri case. On December 20th of 2014, my associate informed me that he had taken another job. I wasn't surprised because I had observed the toll that the prior months had taken on him, as he was just in his 2nd year of practice, and really, no one would be ready to face what we were facing at that time. In addition to that, 10 days later, on January 1st, the new 10-year experienced lawyer was supposed to begin. But on January 2nd, she informed me that she needed to delay that for first 1 month, and then after 1 month, it was delayed again for a 2nd month, and at that time, it was then delayed for a 3rd month. So basically, at the same time that I had what began as a very cordial meeting with the couple, it was almost on the very day that I learned I was now 100% on my own, facing all of the deadlines and depositions I had over the next 90 days in that Missouri discrimination case. And my anxiety level was shot above the roof. And so when I believe that's the time when I did completely lose my objectivity with this couple. And out of everything I was facing, I very unfortunately had the bad judgment to engage in negotiations with the husband as if he was indeed my opposing counsel and not my client. So how do you know if you can trust me today to not do the same thing again? As my attorney stated, I decided that the best thing to do was to wind down litigation because I myself don't want to repeat that most shameful conduct of my 61 years. I am finishing out litigation for one client that I've had for several years, and at the end of this piece of litigation, I will engage in no more. I have been accepting only estate planning matters and small to medium-sized transactions. I've also engaged in some employment negotiations for various clients when they're either getting ready to accept a job or are negotiating their departure from a job, and that's work I've been doing for over 30 years. So it's not stressful to me. I've also informed all those clients that if anything would go to litigation, I wouldn't be their litigator, but that I would assist them in finding somebody who was very good. More importantly, or at least as importantly, I have engaged in a lot of recovery work. I feel very grateful to be in the Kansas system of attorney discipline because one of the first things that happened after the reports were filed against me that initiated this process is that Ann McDonald of KLAP reached out to me. And she said, Linda, I'm in touch with you because 2 filings have been made in a short time, and whenever that occurs, KLAP is assuming that there is a stress process or some other negative health process that is going on, or someone who has been free of disciplinary violations wouldn't all of a sudden be in the middle of 2 of them. And we met together, and she suggested that I begin meditating and said that that was a very useful tool for many, many members of the Kansas Bar. Now, at that time, I was already engaged in intensive counseling. I self-referred to counseling 9 months after I had what I will call as the blow-up with this couple. And that would be the same time that Mr. Hamill described as when I took 3 weeks off of work to recover from exhaustion, to begin intensive counseling for anxiety and for grief. And I also then really tackled the sciatica and some of the other physical side effects of all the anxiety with as much physical therapy and healthy exercise as I could. I have strenuously continued on that path. It's been 18 months of probation plus about 6 months before that when I actually began both the physical and the emotional work to become my former self and improved. So today I feel entirely free of anxiety. I have felt free of anxiety for a good 7 to 9 months. And prior to that, I would say that I was experiencing what would be a more normal state of anxiety, but it more than a year has passed since I was in that very compromised condition that I deeply regret and am doing everything in my power to ensure will never have a chance to arise again. I would like to address any question that you have, but first I just want to unequivocally say I do not contest a single one of the charges that has been brought against me. I committed every last one of them. We filed exceptions only to correct some facts that were in the record, but those facts are not material. What's material is whether you can trust me again.
Do we have any questions of council?
I do. In the October 2015 diversion, one of the conditions was that you complete 16 hours of continuing legal education, 6 of which were to be ethics. Have you done that?
That, I would say, that's a complicated answer. I failed that. I had the 16 hours plus the normal 2 hours of professional responsibility or ethics, but I had failed in my compromise note to specifically schedule myself for 4 additional hours of ethics. Since that, yes, I'm in full compliance. I have made that up. I've always tried to get more than what was required of me, and I think in the year prior to my anxiety and failings beginning, I had 150 hours because I had gone to a month-long trial camp. So I am someone who strives to remain ahead of what's expected of me each year.
Do we have any further questions? All right, thank you, council.
Justice Johnson, I'd like to take a stab at answering the loan, when the loan happened. Suit was filed on February 28th of 2014 in volume 2 of the record at page 302 and 303. She's talking about that the client had been fired and they were waiting 4 months for his service letter to arrive. After which time we could file suit. He confessed to me that he was desperate in need for money, and he wanted me to just try and settle with the other side for something like $10,000. And I said, I'll check the canons of ethics, and if I can make a loan to you for that amount, is that all you would need? And then she found out what prime was, or what the interest rate was on a personal loan, and so she lent him $20,000 at an interest rate of prime plus 2. So I would say that that would have occurred within the time period immediately before filing suit in February of 2014. My other comment is the fact that Mrs. N somehow induced her into taking this case by providing false information. In the pleadings, she alleged that there was a window between 2006 and 2009. She didn't file suit until February of 13. The statute ran even if the very last date that she alleged Mrs. N gave as the date, the case wasn't viable. But then she also wanted to argue that because of the downturn in the economic thing, that they might not have realized, and the court rejected both of those.
Does that conclude your presentation?
Yes, it does.
Do we have any further questions? Thank you, counsel. We thank all three of you for your arguments this morning and this afternoon. Court will take this matter under advisement.